morning. My name is Nick Zangarelli. I'm a consumer bankruptcy practitioner from Cincinnati, Ohio. Primarily practice in Southern District of Ohio and Eastern District of Kentucky. A lot of my focus today is going to be on legislative changes that can be made. So I hope that some of the things that I'm saying are not too painfully obvious, but it will at least give some perspectives from somebody who has been in the trenches on some things that are painfully overdue to be changed within the bankruptcy process. And my hope is that the ABI will join together with NACBA and other like-minded organizations to bring about this type of change that will make for a better bankruptcy system from the consumer perspective. One of the most obvious ones is to eliminate credit counsel. This is a completely useless requirement for entry to bankruptcy that really serves no one. The perceived purpose of the credit counseling requirement when it was created was to provide potential bankruptcy debtors with alternatives to bankruptcy prior to filing bankruptcy. I personally am aware of no individual or family that has pursued an alternative to bankruptcy as a result of going through the credit counseling requirement. It's a meaningless hoop to jump through in order to get your piece of paper that is your ticket into bankruptcy. Additionally, it creates an additional financial and logistical hurdle for people that are pursuing bankruptcy relief. And this is something that can cause catastrophic consequences, not from a financial perspective so much. I mean, we're talking, $20 to $30, which is nothing for the people sitting around this table, but that's lunch for a lot of our clients, and it does actually make a difference to them because they are at the tipping point. That's why they're coming into bankruptcy to begin with. But the more important hurdle is the logistical hurdle. Because I have clients routinely that have had their car repossessed. That's their way to work. I have clients that just became aware that their house was going to go to auction. Now, I know that that is miserable, head in the sand type of things that my clients bear some responsibility for. But if they do not have the ability to come into bankruptcy because the credit counseling service is closed or what have you, and they just found out the day before. I had a client, this was a few years ago, but I had a client who, I kid you not, the mortgage creditor told them, look, you've got a court case coming up next week. It's on Thursday. Make sure that you're there, and we're going to keep working this out. It was the auction date. When they came into my office, that's when I told him, yeah, that's the date that your house is going to be auctioned. And we had to hurry up in order to get him filed, and credit counseling was part of that. The financial education requirement I do think is valuable, provided that it is valuable information that is being provided to them. I believe that there should probably be some additional vetting that goes out there to make sure that the information, the financial education providers are not just being a hoop to jump through, so that we aren't having repeat customers. That is not what bankruptcy practitioners are after. We are looking to get people to a financial fresh start that does not then require a second fresh start. I've had a lot of clients that go through good classes that say, yes, I got budgeting tools that allow me to be able to see what I truly spend on a weekly, monthly, yearly basis so that I'm not falling back into a credit trap. We need a means to be able to discharge student loan debt in bankruptcy. Of course, I think this is obvious to everybody. We're facing the next bubble right now. The prior bubble was the mortgage collapse. The next bubble is going to be student loans, if we're not already seeing that bubble pop now. I have clients that have filed Chapter 13 solely for the purpose of being able to pay something less over the course of the next 3 to 5 years and to receive some level of protection from aggressive student loan creditors. And I'm primarily focused on private student loan creditors. The government has at least allowed some type of a move out through the income-based repayment plan. This is a relatively new plan. I think one of the unforeseen consequences that we're going to see on this when they start to complete is the income tax issues of that. And that's going to be something that's going to have to be dealt with at some point as well, because that could be another bubble that comes down the pipe there to the extent that people do complete this path. But for the private student lenders, they see themselves as having the greatest level of protection of any creditor out there. They are more protected than income taxes. which is insane. Back when the Bruner test, which is the standard in the Sixth Circuit where I practice, was created, there was a path to be able to eliminate student loan debt. It was a path not unlike that of income taxes. But legislatively, that path has eroded to the point that it is now eliminated, and they have a super duper level of protection. Where I heard one creditor's attorney say at a seminar, and I've quoted this more times I can count, you almost need a letter from God to have a student loan discharge in bankruptcy.
They don't accept it anymore.
What's it? You're right. The letter from God is rejected. Yeah. Right.
What would you do this day, student loan discharge?
I would probably take it back to where we were at pre-1994 or something akin to that. I don't think that you can have a situation where people take out, tens of thousands, hundreds of thousands of student loan debt, make no meaningful attempt to repay it, and then have a discharge. I think that has a domino effect on the higher education industry. You see the cost of tuition continue to go up. That actually needs to go in another direction. That's a topic for another day. And you start to see the availability of funds begin to eliminate for that. But I think if you do know that there is a means to be able to get rid of it, I think student lenders become far more conservative with their lending standards. They're not just giving out money to kids that have no idea what it is that they should do with it. Some of them are just using it to buy bigger apartments. Some of them are using it to go on vacations. Because the money is there, and you're giving it to kids that have no idea what to do with it. Yes, sir.
Yeah, so,
I'm sorry.
I know. Thanks. So, to that exact point, do you draw, in the issue of student loan dischargeability, and it probably comes as no surprise that this issue is coming up a lot today and in general, do you draw a distinction between between debt acquired for purposes of trade schools versus four-year undergraduate versus graduate education? And similarly, do you draw a distinction, or should there be a distinction drawn between debt used for tuition versus debt used for living expenses?
I do think that there should be some distinguishing between for-profit and not-for-profit. And that is something that, to a certain degree, exists within the bankruptcy code now. There was actually, my understanding is a Ninth Circuit BAP opinion that just came out last week that I read a couple of days ago that I think could be groundbreaking. Because if it is a not unqualified higher education institution, there was a distinguishing factor in that to say that, well, it's funds extended as opposed to being a loan, that a loan is not funds received. So if that catches on, perhaps that solves the problem there, but we're still in the infancy of that case, and I would love to see it catch on throughout the country.
Another tool you might look at, in our district, the Department of Education and the Justice Department have acquiesced in consent judgments in the adversaries that if the debtor will go into the income contingent repayment program, at the end of the payment period, they get a bankruptcy discharge. So there's no forgiveness of indebtedness income recognized at the end. And the Department of Education has signed off on this in stipulated judgment.
Now, this is governmental only though, correct?
Yes.
So the private student lenders have not come into this.
No. Educational Credit Management agreed to it at least one case.
Okay.
If I could follow up along those same lines, when you talk about the Bruner test, is the problem with regard to the discharge, the Bruner test, or the application of the Bruner test by the courts, or the position taken by the creditor coming in?
I think the Bruner test itself, unfortunately, is flawed because it is too high of a mountain to climb for almost any debtor. It's a totality of the circumstances where it's very subjective, but the problem is that the factors that you have to meet from the perspective of almost every court out there is nearly impossible. I tell my clients, if you can discharge a student loan, I feel sorry for you because you really don't have a terrible life that's left ahead of you, because that's what they're saying. You have no hope.
So if the Bruner tests were eliminated, you think it would be a fairer playing field? That's what it is.
I'm saying that we should have more of a specific calculus that is more akin to that of income tax. I'm almost out of time, and I just want to touch on two more items very, very quickly. One, I think, is a very simple legislative change, and that's an adjustment of the debt ceiling. Right now, we have people that are going into chapter 11s. A lot of that is because of the student loan issue, where you have people that are disqualified from chapter 13 because of the amount of student loan debt that they have. In 1994, it was about a 2.5 times increase. I'm not saying we see anything that big, but perhaps a 1.5 to double increase would put people in chapter 13 that otherwise are, the spur peg in the round hole of chapter 11. And I'm out of time. I don't want to infringe on other people's time.
Thank you.
Thank you.
Thank you very much, and we look forward to any other comments that you want to send throughout this process.
Consumer Commission at ABI Board.
Okay, I think we've been done, okay.
Good morning, ladies and gentlemen. Just 3 or 4 comments on behalf of debtors. The first comment is that the new 341 meeting notice is very confusing to debtors. They have no idea what the date of the meeting is and the time of the meeting. And the reason for that is the meeting date and time is on the second page in very small writing. I think the meeting date and time should be on the first page, just like any other court hearing notice. It should be centered, it should be in large letters, it should be bolded. I can't tell you how many consumers call me up and ask me after receiving the notice, when's the meeting? And naturally, if they're pro se, they may very well miss the meeting, simply because of the new format. So I would certainly suggest that we modify the forms, we put the meeting date, time, etc. on the first page in the center. So that'll be my first comment. The second comment I get from consumers is that they have no idea after receiving the notice, the date, the time of the 341 meeting, that they have to file the second credit counseling requirement. Read Bankruptcy Code section 109H. And the reason for that is the new form does not mention it. So the first thing they have to do after filing a bankruptcy petition to obtain a discharge is to make sure that they get the financial management course completed. But the form notifying them of the 341 meeting doesn't even mention it. I think that's a disaster, really. I mean, the first thing they should be told is, in order to receive discharge, they have to complete the financial management course. So that would be my second point. Probably underneath the revised form, they should be, the first instruction they should be giving is to obtain a discharge of bankruptcy, you have to do this course. It should be a crystal clear reminder for the consumer. With regard to just a typical routine administration of a simple Chapter 7 case, I find that debtors' attorneys and Chapter 7 trustees find as well that it's confusing that under Schedule A/B that there's no equity provision for the real estate. I can't tell you many times I've been sitting in front of a trustee and they ask me what's the equity cushion of the property, and we're looking at the new forms and both of us don't know. So we're flipping through the forms. It used to be right there. The real estate, the mortgage, the equity, the fair market value, all the numbers that you needed to evaluate whether there's any equity in the property was right in front of you. Now it's separated on different pages. So I think they should definitely modify the forms with regard to the real estate and clearly put all 3 or 4 numbers that are necessary for the Chapter 7 trustee to determine if they need liquidated property, the real estate contains non-exempt equity, and it shouldn't be necessary for a busy trustee to be flipping through forms. On page 15 is the equity of the property as opposed to Schedule D. I think the form should allow a trustee who has probably 10, 15 cases every hour to determine very quickly what the equity cushion is in the property. So just another defect in the new forms. And, it's a minority opinion, but I think that trustees deserve a raise. I have a good relationship with all my Chapter 7 trustees. And,
We do now.
I'm an advocate for an increase in the no-look fee, and that's taking place in our district now as well. But I don't know if it's 10 or 15 years or more, but there's been no statutory raise, and I think $60.
23 years.
23 years.
But who's counting?
Yeah. 15 years. So I think to be fair, I do advocate for the increase in the no-look fee, Chapter 13 cases on behalf of the debtors' attorneys. But out of fairness, should trustees deserve a raise as well? It's the end of my comments today. Thank you.
Thank you. Any questions, anyone?
structure, regarding the forms, don't forget, you can make those suggestions directly to the Rules Committee. And I've heard quite a few suggestions today that could be directed to them also. Because I know that they listen to all those suggestions, they take them all up and consider them.
In fact,
And you could do that right on the website, I think.
Exactly. I would suggest that you try to aggregate them, and if you put it in as a suggestion from NACBA itself, it will carry them all.
Certainly work on that. Thank you very much.
Thank you very much.
I have Wayne Silver next.
Morning, everyone.
Morning.
Things you know me.
Yeah, Wayne.
Thank you very much. I practice in Northern California. Recently, my office is just a few doors down from Kathy's. My practice has evolved into one of bankruptcy litigation, and I've been involved in bankruptcy crimes. And I want to confine my comments today to a very narrow slice of what we all do. And I think to speak my mind, and nobody can hold me in attention. So, I want to talk about the fact that bankruptcy court is different from district court.
Is that good or bad?
It's a different place. And when you go into bankruptcy court, as a bankruptcy debtor, and you have the unfortunate luck to be sued for non-dischargeability, for example, the first thing that happens is the federal rules of civil procedure apply. All the rules of discovery. So, for example, I had a case where there was an e-discovery dispute in a non-dischargeability 523 case. And that dispute got bigger and got bigger and got bigger and got bigger. And at one point, there was a motion for sanctions, and it was the creditor was asking for $135,000 in sanctions over a document request. Many years ago, in California, when you had a dispute that was less than a certain dollar amount, I think it was $25,000, I'm not sure. I think it was about $25,000. You went to municipal court, and there were different rules in municipal court. Rules of discovery were different, easier, they were simple, the rules of pleading were different. And so for those small disputes, you didn't have to deal with this tremendous amount of things we had to deal with in the Superior Court, where the disputes were larger. Now in California, they do it a little bit differently. They have something called unlimited cases and limited cases, and the breakdown is $25,000. If you get sued for less than $25,000, you fall under a different set of procedures for discovery. It's much more limited. There's a case questionnaire, the plaintiff has to disclose the witnesses, the documents, etc. You can only do a combination of 35 interrogatories, requests for admissions, document requests, and you get one deposition. And of course, you can go to the judge and you can say, this is a complicated dispute, I need more. So, I was thinking about that in terms of my bankruptcy practice, and wouldn't that be a great idea? What if in bankruptcy court, if you have a consumer 523 case or a 727 case, there was a different set of rules than the federal rules of civil procedure that apply to the mega cases in district court where they have jury boxes and you do jury things. We're in bankruptcy court. And so, why can't we have modified procedures in bankruptcy court to address the fact that most of my clients, to put it mildly, can't afford to hire a discovery expert. They don't have the money for that. It falls on the debtor's attorney if they're lucky enough to have an attorney. And if I say this, I don't mean to be out of line at all, but if you send a normal consumer debtor, a regular consumer debtor, a request for production of documents, like what I see, and you read through the instructions and the definitions, the game's over. They can't do that. They have no ESI and metadata and what? And of course, if they don't do it, well, it's spoliation. Oh my goodness, we're going to go for terminating sanctions in this case. We have to win this case because you didn't produce your text messages.
So I'm curious why the amendment to Rule 26.1, which dealt with the relative access of parties to, and the amount of controversy in terms of their abilities, and the financial resources isn't enough to provide the flexibility.
It's proportionality is a great start. It's a great start, but it doesn't go far enough. It works well in district court context. I think it's terrific, where you've got competent counsel on both sides and they can meet and confer and they can figure it out. It's terrific. But take your pro per debtor, for example. There needs to be, the federal rules of bankruptcy procedure. There's a mechanism there that could be used to shrink down, compress, reduce, whatever you want to say. These rules apply to all cases, so that bankruptcy attorneys and pro se debtors can have a shot in bankruptcy court to defend these 523 cases.
Wayne, as a former chair of the Rules Committee, I think you've got a really good idea, and the best way to present that to the Rules Committee would be a proposed draft rule, amended rule, that would perhaps set up new rules for discovery in cases that you would define under a certain level of dispute. But the idea without some concrete specification is hard to deal with.
I agree. So I'll look at certain people to help me draft. But there are examples.
I don't know if specificity necessarily helps you. Now, what we did in our district to deal with this is we have a standard Rule 26 order, which basically says discovery is going to be handled informally. You don't have to follow these requirements for discovery conferences, et cetera, et cetera, et cetera. And then if there's a problem, someone would file a motion and would get a hearing, but we hardly ever had any problem, particularly in the small cases.
That's a great idea. I would like to see more of that in more districts. There are some districts when you get sued, unfortunately, you don't have that benefit, and you get, my experience, in Northern District is similar to Central District, California. It depends upon where you are in the country, but I know that it's overwhelming. And there's another slice to this, and it's a little bit more, doesn't happen as often, but I do get involved in cases where there are parallel criminal and civil proceedings. And when you've got debtors that are, they don't have attorneys, and they're being sued by the U.S. Trustee's Office, for example, in a 727 case, and they have no idea what to do. And that was part of the other thing that I put into my remarks. I would also, as a subsection of this, is there any way that people that really need bankruptcy, the people that are pro se, the people that can't even afford lawyers, can have access to some sort of counsel when they get sued, particularly in 727 cases, and particularly by the U.S. trustee? That was sort of the part B of one of my pet peeves. I do get called into those cases from time to time, and generally I have to defend them on a completely shoestring budget. And it is the Justice Department, after all, and it's the U.S. trustee going after a debtor. And if it's a parallel investigation, the debtor has no idea that maybe there's this thing called the Fifth Amendment, and it shouldn't be necessarily the biggest problem in their life is not a discharge. Maybe there's a bigger problem. So, I don't know, I'm kind of going aside here, but there should be, as part of the fact that bankruptcy court is different from district court, maybe there's a way that we can find some sort of legal services or something to give pro se debtors, true bankrupts, an opportunity to some sort of counsel, because these matters can spin out of control.
Leaving aside the criminal aspect, we would perhaps have access to public defenders and things like that. But I know there are some courts, including one of mine, where they have a list of people who are both creditors and debtors attorneys who agree to at least speak with a pro se debtor when there's an adversary proceeding. And I know some of those courts have also either subtly or overtly said, if you're on that list, you're going to get paid more for your bankruptcy representation because you've shown you're a good person. Is that something that you have in your jurisdiction, or would something like that
be
a recommendation that could be made by a commission to courts to start maintaining those pro bono lists?
That's one that would work. I think that would be something. There are some pilot projects, that, work in that sort of vein. There are some law schools, I know the University of Santa Clara has a program, where they will take and defend some debtors that are pro se, but there needs to be a whole lot more of that.
Wayne, can I just ask on your proposal, so your experience is that the fee shifting provision in 523 does not act as a deterrent to unnecessary litigation?
No. No, and there's a bunch of reasons why. I know I'm running out of time, so I'm going to have to yield my time. But there's a bunch of reasons why that is not effective enough. So I take it that I'm running low on time.
One question, well, why can't you as a litigant ask the judge for Rule 16 conference and use 16B and ask the judge to be a traffic manager to have discovery that fits the case rather than what fits the rules?
Do it all the time, great suggestion, but you gotta know how to do it. And why does it have to be, I think the default should be the other way. See, I think you shouldn't have to ask. I think when you come into bankruptcy court and you fit into that slice of a consumer debtor being sued by Bank of X, who's got a big tall building law firm, there should be a switch, but you don't have to ask for anything. You get the modified procedure, and they're the ones that have to ask and say, well, in this case, we've got serious issues with this debtor. It's a bad debtor. You know, we need to go out and do 47 depositions. I think my time might be up.
Thank you.
Thank you. Just an editorial, but getting back to Ed's point, Cliff, is being a nice guy now part of Section 330 review? Because it is. I'm delighted.
We're nice
So,
Paul, you're on and you have 10 minutes.
yes. Well, my name is Paul Bach, the ACH, just like the composer. I hope what I'm going to tell you is music to your ears. To use one of my usual type things, I want to tell you first of all how odd I am being in this room with you all. As I look around the names that I see in front of me, I've read stuff from many or most of you over the years, and I'm awed that you want to hear my opinion on consumer bankruptcy. So thank you for doing that, first of all. The first thing I want to talk about is, I know that with the current situation in Congress, any talk about statutory change is going to be difficult, may not be a good idea type thing. Most of the things I think that I'm going to talk about deal with application more than changing statutory language. But the one I do think that we need to talk about, that needs to be mentioned about changing from a statute standpoint, is the debt limits. One other person mentioned the debt limits earlier. My practice is, I do 7-11s and 13s. I tend to do difficult cases. Other attorneys tend to refer me cases they can't handle. I do difficult, I've dealt with many of you over the years, you know my name, and I appreciate that, but these are difficult cases, and almost always I'm bumping up against the debt limit. Chapter 11 for a consumer debtor, or even a slightly business debtor, is a much more expensive process. You go from the standardized fees, or even an hourly fee on a non-standard fees in Chapter 13 to 20, 30,000, which can pace the bankruptcy solution out of the equation. So I think one of the things that needs to be talked about, if we're going to improve bankruptcy, if we're going to improve consumer practice, is dealing with these debt limits. In many areas of the country, I'm aware debt limits are not an issue. In my area, in my district, and I practice exclusively in the North District of Illinois, debt limits for my clients are a big problem. And many times I have to do cases in Chapter 11 as opposed to Chapter 13. I think that one way of doing this is the trustees in my district, in Chapter 13, rigorously enforce the debt limits. I think that there could be some prosecutorial thoughts about not enforcing debt limits in cases, to keep more cases in Chapter 13, as opposed to forcing someone to convert to a Chapter 11, which is going to be a much more expensive process. part of what I think that we're all here for is that because bankruptcy gives debtors discharge, it gives them relief, it gives them a chance to work out their financial solution. If our goal is to do that, then this is something that I think that should be seriously considered. I know that there's another AGI commission that considered making a Chapter 13 applicable to business, and I think they call it Chapter 14. I read something about that. I think that's a great idea too, but it's not what we're talking about today. But I think the debt limits need to be seriously looked at, either substantially raised. The raise that we get every 3 years from the cost of living increase just doesn't cut it. And
do you have a number in mind?
$2 million.
And is this for secured debt or unsecured debt?
I think both. If I was to pick a number off the top of my head,
And is it student loans in the unsecured debt that's the problem, or is it somebody has
Underwater mortgage?
underwater mortgages? You know, I would tell you, I tend to do more higher income type clients, people who are in business or they're trying to use bankruptcy as a tool in order to get them out of their problems. Student loans are a considerable issue, but generally they're not the biggest problem. Usually it's personal guarantees on business obligations. Usually it's going to be underwater mortgages. My area is the North Shore area of Chicago, and tends to have, and I live there, and the real estate values from the 2007 and prior were ridiculous. There are many homes that are up in the millions of dollars. So I see these debt limits affect people, and trying to help people do these things is a big problem. And that's why I say, you know, if I had to pick a number, I'd say $2 million for the secured debt limit, and $750,000 at least, or maybe $1 million for the unsecured debt limit. You know, when these debt limits were originally made, when the code was put into force in 1978, we had a different economic situation in this country. That's not what we have today. And I just think that if we're trying to use bankruptcy to help people work out the problem, I think that's the goal. I really do think that's the goal is, and that's part of what I enjoy about bankruptcy practice is helping people. And there's nothing that gives me a bigger smile when I get a notice that someone got in Chapter 13 discharge or Chapter 11 discharge. It's a great day. But we can't do that. So, but that's my question on the debt limits.
Paul.
Yes.
Before you leave that, would an exclusion of the debtor's residence from the debt limits solve a lot of your troubles?
I think so, but not always, because like I said, a lot of my clients are people with business, and they're going to have personal and they're going to have personal guarantees that sometimes far exceed that. The other thing is just to answer your question, is that in the Seventh Circuit we have a case called In Re Day, if I recall, which basically deals with underwater mortgages. If we counted things that were secured at how it was secured at the secured day at the time, basically I think taking that out, I think that would help as well.
Right. And as far as prosecutorial discretion, would you mentioned that as an option if the system provided a notice to the creditor community that it's over debt limits, but it's proceeding at 13 absent objection and nobody complained, would that potentially solve your problem?
I think also giving a bankruptcy judge the authority to waive the debt limit that's been a particular situation might also be a solution as well.
Yeah. Sorry.
That's my point. I also share Mr. Haller's comments about trustee documents, about trustee documents being in different form. And I think part of what to say is I'm a small practitioner. I practice law with myself and my wife, and we have no staff right now. Okay? And you also have many firms who have tons of staff and have the ability to do that. And we're all trying to get our documents for various cases to the same trustees using all these different systems. And although I am learning, I am not the most the technology type based, and different trustees have different systems and different passwords and everything like that. My suggestion is that somehow delivery to trustees, and it's going to be through electronic system, and that's fine, be simplified, and everybody has to use the same system. In Chicago, one of the nice things is on the court's website, there's trustees with various lists of what they want. But I think if you look at that list, some don't want anything. Some want different things. I think it needs to be unified and made sync. Okay? Since I do chapter 11 on a consumer basis, and I mentioned one of my annoyances is that you have chapter 11 on a consumer basis who complete their plan and make their payments. And then in order to get their discharges when the case is closed, they have to reopen that case and pay over $1,000 just to get their discharge. And I think that's something that can be done on a non-administrative basis to waive. I know if you're going to do a motion regarding the discharge, to enforce discharge, that's free. But in order to obtain the discharge, it's going to cost someone $1,100. I think it's between $1,000 and $1,100. I don't remember the number off the top of my head. But the motion to reopen is something I think that can be done on an administrative basis.
The problem is that you had to close the case in the first place to avoid ongoing trustee fees.
I agree.
So if you had a proposal that stopped trustee fees upon confirmation, that would eliminate the problem entirely, wouldn't it?
Correct. So the other thing, and I know I've talked a lot already, is in regards to chapter 11, is that one of the problems that I see with chapter 11 is chapter 11 was, in a consumer basis, was designed not for consumers, but for businesses. And all the payments take place outside of the business. And in chapter 13, all these payments are being made by a trustee, and there's records and everything like that. And I had a conversation with a chapter 13 trustee who's serving as a dispersing agent, that perhaps a way to fix that on a consumer basis, so that we make sure that the records and these things are actually being paid, that these things be done by some sort of a dispersing agent instead of the debtor directly. You know, I represent debtors. There's a reason why a lot of times people are in bankruptcy, but I think that may be an effective solution in order to make chapter 11 consumer cases go more smoothly.
Thank you.
Thank you. Thank you for your time.
Next up is Brad Vogt. Voted, I'm sorry. Voted.
Can you, before you start, can you tell us where you're from and what your practice is?
Yes, Judge. I'm from Birmingham, Alabama, and I'm a debtor's attorney. My firm practices across Alabama, Mississippi, and been in a few other, in Tennessee, and a few other states also. And Judge Ferris and Judge Brown, Professor Law, as members of the commission, I do appreciate the opportunity to speak to you this morning. I do appreciate the ABI appointing this commission. I think the work you're doing is very important. And it's really an honor to talk to the people at this table. I have great respect for everyone here. I have learned from some of the previous speakers, and I will agree that trustees do need an increase in pay. So do judges, retired judges. Members of government. So with coalition, we're all ears. So having said that, it's please excuse me, I'm going to refer to my notes a good bit because there are certain things I want to make sure I get in within the 10 minutes that we speak. It's my understanding that the objective of this commission, or at least one of the objectives, is to modernize the consumer bankruptcy system with practical and cost-effective recommendations. And my statement this morning is intended to be directed towards both of those goals. A little bit of background. And Judge Parrish, you asked where I'm from. I'm from Birmingham. Attended law school in Birmingham at Cumberland School of Law at Stanford University. My first exposure to the bankruptcy system was while in law school. I actually worked for the United States trustee in the state of Alabama. Now, those of you that have been around know that there aren't many people that work for the U.S. trustee in the state of Alabama. Like North Carolina, we opted out of the U.S. trustee program, but back in the early, mid-'80s, the Northern District of Alabama was one of the pilot programs So I had an opportunity to work with the U.S. trustee program, and again, learned a lot about bankruptcy there. I think it probably impacted the direction my law career was going to go. My law firm was established in 1989 in Birmingham. We have offices across the state of Alabama, across the state of Mississippi, we're in Tennessee, we have it in Florida, North Carolina, and Texas. We have filed tens of thousands of petitions under Chapter 7, 12, and 13. We don't do any 11 work, but we've helped, again, many people obtain fresh starts in bankruptcy. And it's from this experience that I want to speak to you today. I also served as a member of the board of directors of the National Association of Consumer Bankruptcy Attorneys. I was one of its first 50 members 25 years ago. I was on the board of directors during the time NACBA was being debated, and then I served as its first executive director as it was being implemented. So I've had a chance to be involved with the consumer bankruptcy system from a lot of different perspectives. The thing I asked Professor Wallace to be able to speak to about this morning, and I want to be focused, I certainly could contribute or would like to contribute in a lot of different areas of consumer bankruptcy law, but the two areas that impact virtually every individual that enters the bankruptcy system are the two mandates of NACBA, that a debtor receive a credit counseling briefing before filing bankruptcy, and then a debtor education program after filing bankruptcy and before discharge. It is my opinion that these programs are doing exactly what we thought they would do when they were being debated, and that, frankly, is do nothing but waste debtors' time and add costs and bureaucracy to the bankruptcy system. To use the words that are included in this commission's objective, they're not practical, and they're certainly not cost-effective. Unlike virtually any other provision in the bankruptcy code, though, they affect every single individual debtor that enters the bankruptcy system. Very, very few exclusions for individuals that file bankruptcy. So they permeate the system, they're not practical, and they're not cost-effective.
So I was curious about your comment because I think on the ticket in, the credit counseling, the literature's been pretty clear about that. The comments have been pretty uniform. On the ticket out, it's a little more inconsistent in my experience. And so, but you seem to tar them with the same.
Yeah, no, Your Honor, you're correct. I don't think either of them serve practical or cost-effective purposes, but I would agree that the consensus is that the ticket in is far less effective than the post-bankruptcy filing. And the reason is, and it's been observed by studies done by the National Consumer Law Center, by the GAO, the government's General Administration Office, and my experience and the experience of other debtors' attorneys will verify this. By the time an individual gets to see a bankruptcy attorney, they're desperate. The stated intention of the debtor education program was to help individuals to perhaps explore other options outside of bankruptcy. In the vast majority of cases, by the time the individual gets to one of our offices, they don't have a lot of other options. Now, bankruptcy should not be a first option. I make a living, most of y'all do, from the bankruptcy system, but I think most of us agree here, bankruptcy should not be a first option. But by the time they come to our office, there's a foreclosure or a garnishment or a repossession, distress has caused a marriage to fall apart, causing family problems, they need immediate relief. And the credit counseling is nothing other than a hoop they have to jump through, spend their money on, take their time doing in order to get into the bankruptcy system. And I don't believe that's fair. Again, it's not practical and it's not cost effective. Although there is some benefit to to the second course, the post-filing course. It's based upon the assumption that I think is wrong, and studies indicate is wrong, that people that file bankruptcy, as a rule, manage their money poorly. That may be the case with some of them, but after having done this for over 25 years, I'll tell you it's not the case with all of them. They all should not be painted with the same broad brush. Many people are in bankruptcy through little or no fault of their own. Perhaps it's because they took a chance and tried to start a business. Perhaps it's because they got ill. Perhaps it's because they went through divorce. There are many reasons why people file bankruptcy. But to make the broad assumption that they're there because of poor financial skills or poor financial management is just wrong. And it's not fair. Again, it's just not practical. Judge, I wouldn't be opposed to some type of program that was discretionary, perhaps used by a judge in certain cases. Maybe in a Chapter 13 case where a debtor misses payments and the trustee is moved to dismiss the case. Perhaps as a condition of continuing with the Chapter 13, some sort of financial management course or budgeting course could be used at the discretion of the court. But these are just not cost effective, they're not practical, they should be eliminated, I believe.
Can I say, in your jurisdictions, in my jurisdiction, the Chapter 13 trustees provide for free the debtor education course, and they file the certificates, and it is tailored not only towards general financial education, but towards what things you have to do while you're in Chapter 13. Do your trustees do that? And would that change your perspective on the utility and costs and things like that?
It would help change, and no, the trustees in the districts that I practice in do not provide those courses. I've heard good things about the courses where you practice. I also understand that Hank Hildebrand does a good job up in Nashville. So there are examples of good courses, but again, I'm opposed to them being mandatory. I think using that broad brush is unfair.
Would you draw a distinction between Chapter 7 and Chapter 13 as far as post-petition education?
Your Honor, only in the limited circumstances. I would say that in most Chapter 7 cases, the course provides little benefit. In a Chapter 13 course, where the court and the trustee is involved with the debtor over a period of 36 to 60 months, I can see circumstances where it would be helpful. But again, at the discretion of the court or somebody within the system, not mandatory, not across the board. I know my time's almost up. I do appreciate the opportunity to speak. I'd be glad to answer additional questions. But just to summarize again, your objective is to find ways to make practical and cost-effective changes to the bankruptcy system. I don't think any changes could be more practical or cost-effective than to eliminate these two provisions post haste. Thank you very much.
What percentage of your clients come to you seeking bankruptcy? Do you advise not to file bankruptcy because they have alternatives?
Absolutely, I would say at least half of them, Mr. White, and I say that with all sincerity. My first objective, and my wife asks me about all this all the time. She said, "You make a living filing bankruptcy for people. Why do you help them stay out of bankruptcy?" My objective is to help them get their life back on course. And if they can do it without filing bankruptcy, that's where I send them. Now, from a business perspective, I think that generates referrals from other clients to my office. But I would say at least half of the people that come to see me or call us, maybe they call us first and end up not coming in because of the discussion we've had, decide that they should at least explore other options first. Yes, sir, thank you.
For those of us who are not debt relief agencies, how physically long does it take a debtor to do on the internet at credit counsel?
I believe it's mandated, Mr. White, that it's supposed to last at least an hour. There's a mandate. I will tell you that there are some that promote that they can be done very quickly and very cheaply, and that's what it's evolved to. How quickly and how cheaply we get your debtor through the system and get them a certificate. that's how they market to us as debt relief agents.
You ever seen one of these agencies recommend the debtor not file?
I have not once. And that was a concern of ours when this law went into effect. Now I've not seen one.
Thank you.
Yes, sir, thank you.
Thanks very much.
I have to see, I'm gonna go slide your name back, anything else?
No.
Back in club.
In law school, I was known as Mr. Maraschino.
And we'll ask you and all succeeding speakers to tell us not only your name, but where you're from and what your practice is.
Thank you. Thank you for having me address you. Just so you know who I am, because some of you don't know who I am. My name's Gene Melchione. I practice in Waterbury, Connecticut, which is now part of the Rust Belt, depressed area. Unlike many of my distinguished colleagues that have testified before, I have an extremely small bankruptcy practice, taking rather unusual cases and maybe file one case a month. But my background is also unusual in that I previously served as the vice president of the Waterbury Credit Bureau, so I have a credit reporting background. And for the first 10 years of my 35-year-plus practice, I practiced on the creditor side of things. So I have a sort of a schizophrenic view of the practice because I'm extremely conservative when it comes to advising people to dump their debt, if you want to look at it that way. Unfortunately, being late in the program, a lot of the previous speakers have checked off a lot of the boxes that I had thought I might mention. The forms are abhorrent to me, being an Apple Mac user. I'm very much into the graphic view of things and being able to very quickly scan a piece of paper and understand what it says. These forms are terrible. They're just poorly designed is the best way I can address that. The credit counseling issues I think have been covered in depth. The pre-filing credit counseling is really just, as I tell my clients, it's a formality you have to go through, a verification of your budget because maybe the system doesn't trust lawyers to accurately put that budget down on the forms, and to slow you down so that your creditors can pick your bones clean, which is really my viewpoint of what the advanced credit counseling is, although I think the education course is valuable. Trustee document requests, in my district we have about, I would say about 10 Chapter 7 trustees who all have different requests for forms. What I've done is amalgamated the most extreme example of all those and supply more than what's requested. We have one trustee who insists on paper, I'm virtual, everything's electronic. He gets a CD from me, I'm not going to do paper. If you don't like it, take it to the judge. I'm not afraid to pick a fight when it comes to things that I see as being essentially insubstantial. So I think those topics have been covered in depth. What I haven't heard mentioned is a new trend in our district, and I'm not sure that it's a substantive thing, and I'm not sure that this commission is really poised to do anything about that, but we have a problem with a clawback by trustees of parental student loan proceeds. So parents who have taken out student loans for their kids, the proceeds never pass through the debtor's hands. They have gone to the school. Trustee then steps in, sues the school, not the debtor, to recover those proceeds. Since it's non-dischargeable, those loans still have to then be paid, and if the balance is now rolled back to its original loan balance, essentially the parent is now paying it twice because they have to pay the student loan and they have to pay the school, which I think is just an overstep by the trustees in terms of recovering assets for the estate. And I have no problem with trustees who recover assets for the estate. I'm willing to give up assets when they're there because that makes the system work smoother. but this is really a double dip in my opinion, and punishing the debtors for taking out student loans for their kids. And I'm not sure how we can change the statute to deal with that. We're trying to do it on the state level by changing some of the parental requirements for children in education. But again, when you're talking about kids who are above the age of 18, that's a really difficult thing to do when they're essentially not minors anymore. There's no obligation to take care of them. So that's it. I've opened the questions.
I've never done this, nor do I intend to, but how prevalent is trustees going after clawbacks on tuition payments?
As far as I understand, Connecticut leads the nation in that. We have, to my knowledge, well over a dozen, maybe 24 cases, and the schools don't defend because it's not in their economic interest to defend a case over $15,000 when you're talking about an endowment and whatnot of millions. And so, yes, and it has now started to spread to other states. I'm on board of directors for NACBA, and I'm seeing it spread now to Massachusetts and Rhode Island and New York. And the judges approach it differently. We have a really good decision that came out of Massachusetts recently that basically said, no, that's not a fraudulent transfer, but it is starting to spread, and I can see it easily spreading to other parts of the country. And it's something I haven't heard mentioned yet so far this morning.
What's the fix for it?
What's the fix for it? That's the problem. I'm not really sure. What we're looking at is a change in state law that requires parents to provide for the education of their children. In a divorce situation, many times those kinds of things are worked into a divorce decree, so it becomes an element of support, and thus the trustees might back away from it. But again, I'm not sure what this commission can do about that, what Congress can do about it, and whether or not it's really worth opening the door when we're in the early stages of the courts making decisions that maybe when we get to the circuit level, we'll
There was a bill introduced by Chris Collins from upstate New York, a Republican and early Trump supporter in the previous Congress, and that would have changed this.
How many of these cases involve student loans as opposed to well-heeled debtors paying their kids' tuition out of the pocket?
No, they're all with student loans. They're all with student loans. So that's where the double dip comes in, because the parent ends up having to pay the student loan because it's non-dischargeable, and then they have to go back and pay the school for the tuition that was previously covered by the proceeds from the student loan. So they end up paying the tuition twice. And that's what I find extremely disturbing about the trend.
If I could return to the trustee documentary, some folks alluded to this, and you brought it up more directly today. What's happening in terms of sort of punishing debtors' counsel for delivering documents in the wrong way? Is it simply a method, simply an issue of it adding to the timing that it takes you to deliver these, or are you finding that trustees are refusing to hold the 341 meeting? Are they seeking to dismiss the case?
Well, because I guess I must be strong-willed enough, they do, I had an instance where they continued to 341, and when we came back on the continued date, because my client blamed me for that continuation, I let the trustee have it, and on the record, I'm not afraid. Being a creditor's attorney, I can pick a fight with a picket fence. It's not a problem, and so ultimately the trustees backed down from the unreasonable request. What I found most difficult was the one trustee we have that insisted on paper. We have an electronic filing system. Most of our other trustees employ one or two of the other systems for uploading documents. So I burn everything onto a CD and give it to him. And what he does then is have his staff print it all out, and it comes to the 341 hearing with a stack of paper is about 2 inches thick. And doesn't even look at them during the hearing. So it's just a sort of a routine custom thing. What's most disturbing about that is that he's younger than I am.
I've had experiences where in some districts, the local rules make it easier for trustees to dismiss upon allegation that has been non-compliance and non-cooperation.
And I invite that motion,
Right.
so because most judges would then look at the trustee and say, what do you think?
But I appreciate your putting issues in this one.
respect to that. At the same time, not all debtors' attorneys respond in the same.
Practically none of them, and that's the problem.
Yeah, and so the cases do get dismissed. And then when they try and refile because of that, then they've got,
Being
what's right.
dismissed not for failure to produce the document, but documents have been produced just in the wrong way, and the case is dismissed?
A failure to cooperate.
Since when do trustees have rulemaking authority?
Ron?
The dismissal of the case is an appealable order.
Absolutely.
But at the more petty level, you're going to continue 341 meetings that force your client to take more time off from work. And it creates a hostile relationship with the attorney because you could have solved this for me.
Yeah, and just to give you another example, I had a trustee who insisted on bringing the wet signatures to 341, so I brought him 7 copies and asked him to tell me which one's the original.
I have gone to court on these cases where it's a matter of form over substance, not a failure to produce, but someone wanted a paper document versus electronically, for example.
As it turns out, I only had to do it once, because once the trustee was told by the judge, take it out in the hall and get rid of this, it kind of went away. But it's an ongoing problem because it continues.
Yeah, I just suggest that one of the problems is uniformity in the bankruptcy system in so many ways, including the way the judges